Ladies and gentlemen, good morning. It's my pleasure to welcome you to day 2 of the Conference on International Economic Law and Human Rights, from conflict to cooperation. My name is Levent Sabanogullari. I am Senior Legal Counsel at the PCA, the Permanent Court of Arbitration, and currently the head of the PCA's office here in Vienna. And today I have the pleasure of moderating this panel of distinguished speakers on a topic of investment and human rights. Before we do start with our presentations, I should like to take a moment and thank the organizers, not only for organizing and for making this conference happen, but also for inviting us to be a part in it today. Now, human rights norms and international investment law interact in several ways in practice, and we will hear about several of them today from our speakers. For one, both investment law and human rights seek to protect individuals from state interference of property rights. So the question then becomes, what is the appropriate level of protection, and does international investment law has international investment law gotten it right? Second, the investor may commit human rights violations that prompt the host states to adopt a human rights motivated measure that then interferes with the property rights of the investor. And in this scenario, how relevant should the human rights motivation be for an investment tribunal in assessing a treaty breach? And finally, investment law is also seen by many as a tool to prompt and promote good governance because it's set to discipline host states to comply with due process and other human rights standards, because if the host state doesn't, then they will get sued under an investment treaty. So that's the theory, but whether that holds up to empirical scrutiny is another question that we'll be exploring today. Our speakers will be addressing these questions in turn, and I very much look forward to that. They need no introduction, so I will be able to keep it short. Our first speaker is Professor Federico Ortino. Federico is Professor of International Economic Law at King's College London, where he's also the co-director of the Center for International Governance and Dispute Resolution. And he will speak today about investment protection and the protection of property. And with that, Federico, I'll yield the floor to you.
Good morning, and thank you for the introduction. Thank you for the organizers for inviting me. So I start off this panel on investment law and human rights. And the topic which was assigned to me by my dear friend and colleague is investment protection and the protection of property. And given the overall topic of the conference, I thought I would use this opportunity to simply say what investment law is not, although some people may say that it is. The idea that sometimes you can hear, or maybe people may keep it in their heads, is that the protections guaranteed by investment treaties to foreign investors are very much akin to the protection granted by national constitutions or even international human rights. If you think about the protection of property understood broadly through provision on expropriation, for example, but also fairness, procedural fairness, also substantive rationality or reasonableness, one can see the similarities. Now, and that's why some may think that the two are part of the same family. Well, there's a reason why this sometimes is being put forward as an argument. Clearly, it is there to strengthen the authority and legitimacy of the investment treaty or investment treaty systems more broadly. Now, while these similarities clearly are there, if one looks a little bit closer, particularly both at the original features of the system, the investment treaty system, which is relatively young, only built up to some extent after the Second World War, as well as if one looks at the way that that system has been evolved and consolidated, particularly through investor-state dispute settlement, investment treaty arbitration, I think one would be able to see that in fact that apparent parallelism or similarity is really far from reality. And what I would like to argue today is, in fact, that investment treaty system has created super rights, has created super protection, not fundamental rights or human rights to foreign investors that have, in many ways, little in common with what we know as fundamental rights, if you think about national constitutions, or even international human rights, if you're thinking about the international law setting. Now, what I'm going to do is just to give you a couple of, in fact, two sets of evidence to demonstrate this point. Now, the first one focuses on two clauses, traditional clauses on expropriation. This is clearly where some see the parallelism. But I will also talk about the more rare cases of stabilization clauses in investment treaties. So first, expropriation. Now, traditionally, investment treaties, up until the early 2000s, in fact, so the bulk of all existing investment treaties out there, more than 2,000 to some extent, have certain distinctive textual features. Particularly, not only they cover a broad set of interests, not only property interest, but interests, assets, but particularly most of these treaties really take a broad approach in defining what is an expropriation. And particularly making references to concept of indirect expropriation or measures that have equivalent effect to expropriation. Now, and there's plenty of examples. Some of them, I cite here the US EGBIT of 1986, one of the early US bits, where they define expropriation as including any measure, direct or indirect, for example, impairing or depriving the management, control, or value of an investment. Now, what is strikingly, if you look at these thousands of treaties and focusing on the expropriation provision, is that there is really no reference, express reference, to the public policy underlying a potential, allegedly expropriatory measure. Yes, there is a reference to public policy, but that's sort of a condition for lawfulness, which is a different thing. In defining whether something is an expropriation or not, there's no reference. The only textual reference is to the effect, and interpreted in the broadest sense, sometimes expressly in treaties, focusing on whether a certain conduct of the host state has adversely impacted on the value of the investment. Now, this is strikingly because if you look at the contemporaneous understanding of what an expropriation could entail at the international level, it was pretty clear that the public policy reason for why states do things, including affecting properties of aliens, there was clearly a role for the public policy underlying the measure. And equally, if you look at the various national constitutions that were often drafted in those years, talking about the early years after the Second World War, perhaps the biggest constitutional dilemma is to balance when you would permit compensation for the exercise of eminent domain by states, and on the other hand, where states would be free from paying any compensation in the case of their exercise of police powers or the right to regulate in the public interest. This is clearly a big issue. It was clearly reflected in the text of those constitutions. So you have provision on expropriation, on regulation, on limitation. This is quite interesting. So the fact that all this debate was not reflected in those treaties, I take it as an evidence that there was a clear intent, or at least it's plausible to read it, as willingness to provide this extra protection, this super protections to investor rights. Unsurprisingly, the first tribunals that down the line started interpreting those provisions did it exactly in this way. They only focused on whether the measure adopted by the state had a substantial adverse effect on the value of the investment. This is the so-called sole effect doctrine. That's sort of the first. The second one is the stabilization clause. This is a much rarer instance, but it's interesting that you do find some treaties, investment treaties, that include such stabilization clauses. A general stabilization clause usually requires that if there is a change in the law after the investment has been admitted, and that change is prejudicial to the interest of the investment, the investor or the investment will be subject to the previous law at its own request. Now, clearly, this offers quite an extensive protection, and it's akin to stabilization clauses that one finds in state contracts. But the key difference is that in a treaty, it's not really granted specifically to a project or to a specific investor. It's granted to an open-ended list of potential investors that may invest in the future. Italy, for reasons that I one day will investigate, has included such clauses in many of its treaties, still in force. Now, the second set of evidence sort of looks a little bit further down the line. And in fact, it doesn't focus on how treaties were drafted early on. So this is sort of, in fact, I put the blame here on those that drafted those treaties. I now focus on how those treaties were actually applied and interpreted. And yet there's a lot of it, but we don't have time. So I'm going to focus just on one aspect. And particularly is the interpretation that investment treaty arbitration or investment tribunals have interpreted the famous or infamous clause on fair and equitable treatment, FET, which is the most powerful provision you find in investment treaties, at least if you look at the cases that have been successful before tribunals. Now, particularly tribunals have read in those little magic words of fair and equitable many different things. But one of those things is the protection of investors' legitimate expectations. So if a state has created this expectation in the investor, and then down the line it frustrates those expectations, that is seen as a breach of the fair and equitable treatment obligation. So that's an unfair or inequitable treatment. Well, we could talk about sort of how that happened, but my point here is much more narrow. Although there's no reference to this concept in treaties, right? This is a purely jurisprudential or sort of coming out of the arbitral practice. The way that most, not all, but most tribunals have actually applied this concept of protecting investors' legitimate expectations, which is, by the way, a concept that is quite well known in domestic legal systems. The EU legal system has it as well, is in a way which, for the most part, ignores or downplays the role that, again, public policy has in the way that the doctrine has been applied and developed in domestic legal system. And particularly in domestic legal system, even if an applicant manages to establish that the state, the public authorities, have created this reasonable expectation in something that the government will do or not do in the future, the public authorities always have the ability to frustrate that expectation if they can show that there is an overriding public interest that justifies it. Now, this overriding public interest aspect of the doctrine has been, for the most part, ignored by investment tribunals. And if you add to that the fact that tribunals had often been quite liberal in finding the existence of such expectations, particularly focusing on expectation of regulatory stability, again, you can see how the concept of fair and equitable has been used to guarantee regulatory stability to foreign investors. And so the conclusion here, and I draw to a close, is that investment treaties originally, and the way in which they have been interpreted by tribunals, have created super rights or super protections, which have nothing to do with fundamental rights or human rights. And more so, and there are many other examples I could go into, but you can maybe show that there is a certain DNA aspect in the system, which has been difficult and still we haven't managed to somehow modify. And so that's our challenge. But for the moment, I stop here. Thank you.
Thank you very much, Federico, for this very interesting presentation. I want to tie in with something that you said at the end, namely that we haven't managed yet to modify the system, because as we all know, international investment law, the system currently experiences a backlash already for almost a decade, I guess. And one of the reasons, of course, is that, or one of the arguments is that it curtails the policy space of states to take measures that are in the public interest for the benefit of their populations. Now, and states have tried to react to this criticism, and they've tried to amend their treaty drafting in various ways. One of them, for example, is the inclusion of an express right to regulate in a new generation of treaties. Others could be the inclusion of general exception clauses, or maybe interpretive annexes and indirect expropriation, which actually explain what measure amounts to indirect expropriation. And I would like to hear your thoughts on what you think about these approaches. Are they suitable to modify the system? Does it help states? Is there maybe actual case law on this where these were adopted, and have we seen a change in the interpretation of these treaties as a result of these treaty drafting changes?
Now, that's a good question, and I don't think we have time to do that, to answer it fully, in a sense, because there are a lot of different things you mentioned. But I'm going to give you a general approach, and my sense is that we're not there yet. So, and that's for many reasons. So, think about the EU. EU has sort of got onto the investment area. They sort of adopted a new approach, which sort of changes a lot of things, but none of the EU treaties are in force. So, it's there, but, claims brought today, the dozens claims brought today, those new novelties are pretty much irrelevant. And that's one aspect. So it's difficult actually and this is not because the EU has not tried. I mean, it's politically difficult to make those treaties. It's actually quite interesting. So there's this willingness to change, but I suspect because of its controversial nature of the whole system and the way it has developed, we debate about the extent of those changes. And some think, well, you've changed it, but actually not enough. And so the end result is that no changes take place. And so we are left with the original system, which everybody hates. Well, sorry, not everybody. In fact, a lot of people love it. They are silent, at least to my ears, but they are there. But so it's sort of it's a paradox. There's a strong movement to change, but we disagree on how we do it, and so there's no change. Well, I think I'll leave it at that.
Thank you very much. Thank you very much. Are there any questions from the audience for Federico, perhaps?
Just one question on what you were saying about the EU. Obviously, because of basically none of these agreements have come into place. But what is your assessment about the changes per se? Do you think that they correct the super protection? I see your indication. And has something happened in terms of the BITs of the member states? Because in those cases in which there has been no entry into force of the European Union Investment Protection Treaty, member states still keep their BITs. Has there been any effort by the member states to adapt their BITs to the new standards reflected in the EU model, or this simply hasn't happened?
I don't think, as far as I know, I don't think so. There have been some new treaties that have been signed by some member states after 2009. But usually the novelties reflect those introduced by the EU. So, but it's interesting whether, I mean, that's something worth looking, that whether some of the applications of those changes have actually already given light. I'm not aware of any, but that'd be something interesting to look at.
Okay, thank you very much. I think we have time for one more question from the audience. Yes.
Thank you for the presentation. I really enjoyed it. I have a question on your this idea of a super right that you have mentioned, super rights. They're not fundamental rights, but they're super rights. There is an interesting development now taking place in both international and I would say also regional international law, if we can put the European Convention of Human Rights and EU law in there, which is climate change protection. And there is a very relevant judgment of the European Court of Human Rights, just delivered about a month ago. We have already now other decisions, other jurisdictional decisions of international courts on the matter. And it looks as if climate change is developing into the substance of a new super right. It's a fundamental right. Strasbourg has integrated in the right to privacy, but it has done it by making use of the Aarhus Convention, which is not about privacy. So it is developing into something which we are still waiting to see what it actually is, but it's providing quite a lot of protection. And my question would be, all right, so if investment treaties are providing super rights, which are not fundamental rights, how will they be interacting? Of course, nobody knows this, but I'm just launching the questions. How will they be interacting with new super rights, which are emerging as well? In the case of climate change, it is developing now. We don't know exactly how it would look like in a couple of years' time, but it is developing into something new, which is not a conventional fundamental right, but it's looking quite super as well. So the clash between these two super rights, how do you envisage them for the future?
Well, that's a good question. I don't know whether the sort of environmental development are leading to this super rights, but let's assume that that's the case. I mean, this is another fundamental problem which I haven't touched upon, which really makes the attribution of super rights through investment treaty and the enforcement of super rights through this investor-state arbitration mechanism problematic, because differently from the human rights context or the national constitutional context, those treaties and those tribunals are only attributed very limited competences. It's a super right and nothing else around it. Whereas when you usually find fundamental rights or human rights in other contexts, they are embedded in a wider set of rights and principles. And so this is why attributing super rights to a narrow set of issues is idiotic, because you end up with really a super, attributing super right without any counterbalances. Or those counterbalances, this is the struggle of the last 20 years, trying to introduce counterbalances in a system which was created, sort of monothematically, with one function only. So I think that's also the problematic, not the very nature of super right, which you could decide to have, but it's the way it's been embedded, at least, in the same way. I mean, we can sort of draw parallel with the trade system, but you don't find those super rights in trade law.
Thank you very much, Federico. And with that, I think it's time to move to our second speaker. Our second speaker is Dr. Clara López Rodríguez. Clara is a lecturer in Spanish law and deputy director of the Center for Climate Law and Governance at the Dixon Poon School of Law, King's College London. She researches on the interaction between international investment law and human rights, with a focus on the mining industry. And the topic that she'll be presenting today about is invoking human rights against investors. And with that, Clara, I hand the microphone to you.
Thank you very much, Levent. And the Diplomatic Academy for bringing us all here together. So I'm going to present on the topic of the role of human rights in investment arbitration to see if we can find some limits to the super rights that Federico just addressed. And I'm going to try to focus on positive developments. So, even though there are few, I think we should underscore them to understand how we can use the system. So I'm going to center the presentation on a specific sector of the economy, which is mining, to kind of bring to life what we are talking about, the importance of what we are talking about, which is human rights in investment arbitration. So this is a picture of Cerro de Pasco. Cerro de Pasco is a city built around an open pit mine at 4,300 meters above sea level in the Peruvian Andes. The history of Cerro de Pasco can be traced back to 1902, when a foreign corporation, participated inter alia by J.P. Morgan, initiated the exploitation of both copper and silver, both here and in the regional site of La Oroya. Fast forward to today, and Cerro de Pasco is amongst the most polluted regions on Earth, and while local communities have been struggling to bring their claims before international fora, the foreign investor that now owns the site, the Renco Group, has brought several arbitration procedures against the Peruvian state on the grounds that the environmental remediation measures imposed by the state constitute a breach of a bilateral investment treaty. So, why is this important? Well, this case is by no means unique. In the last years, we have at least 31 cases brought by mining foreign corporations against Latin American states. And in the years to come, there will be much more cases. I have to underscore that the green transition is built on minerals, and many developments that we have addressed these days, like AI, are also built on mineral extraction, and switching the whole energy grid from oil and fossil fuels to renewable energy will entail an unprecedented extraction of mineral resources. There's a 2020 World Bank report that analyzes the scale of mineral production, and here you can see the graph, but if you look at the data, it's just something. So, for example, copper and molybdenum, which are essential for green technologies, are located in very specific regions of the world. For example, in Peru and in Chile, and mainly in the areas of the Andes and the Amazon basin, which are in turn inhabited by indigenous peoples and local peasant communities. So well, these are the facts that we're dealing with. Many of these investment disputes regarding mining are adjudicated by arbitral tribunals. So if you see ICSID statistics, you will see that oil, gas, and mining are a very high percentage of the disputes that are adjudicated by investment tribunals. So I'm going to address mainly 3 points today, and it's how do we get human rights in investment arbitration? Well, I will argue that it is within the mandate of investment tribunals to apply human rights. Human rights can be used as a sword, and human rights can be used as a shield to defend state interest. So let's see how this can be done. First of all, I think that it is within the mandate of investment tribunals to apply human rights for 3 reasons. First of all, because under most bilateral investment treaties, the applicable law is not only the bilateral investment treaty or free trade agreement with investment chapter, it is also public international law and domestic law. There is also the principle of systemic integration, which I'm sure you know about, under Article 31.3c of the Vienna Convention on the Law of Treaties, which establishes that treaties, and in this particular case, bilateral investment treaties, should not be interpreted in isolation, but in light of the wider corpus of international law. And finally, a point that I think that it is underscored and under research in the literature is that investment tribunals resolve disputes about an investment. And an investment is a property right that is defined under domestic norms. And in highly regulated sectors, such as mining, the property right of the investor is limited, the configuration of the property right is limited by environmental and human rights norms. So let me move on to the 2 ways in which human rights can be used. And I'm going to start with human rights as a sword because there has been less development in that area. One way in which human rights can be used is under the notion of counterclaims by the state. There are 2 hurdles for a state to file a counterclaim against an investor. First, the jurisdictional hurdle, so you need a wide drafted treaty that enables the state to bring a counterclaim against the investor, and there's a second hurdle, that is you need a positive obligation on the corporation to enforce human rights obligations. So for example, in the case of Orbiter versus Argentina, which I'm sure you have all heard about, the arbitral tribunal admitted the possibility of the state bringing a counterclaim against the investor in procedural terms, but when it had to find a positive obligation on the corporation to implement the human right to water, it couldn't find a positive obligation under public international law, and the arbitral tribunal dismissed the counterclaim. There have been other cases where counterclaims, very few cases, where counterclaims have been successful, and this is the case, for example, of Burlington versus Ecuador. In Burlington versus Ecuador, Ecuador filed a counterclaim against Burlington, which was an oil company. Jurisdictionally, it was done under an agreement between the corporation and the state. And the claim was based on domestic law, chiefly on domestic law. There was also a component of public international law, but chiefly it was domestic law, and it was successful. So the arbitral tribunal decided that the corporation owed around $40 million to the state. And there have been some progressive developments. We have been talking throughout these 2 days about the EU due diligence directive and about how domestic legislations are enacting due diligence regulations, and this may serve in the future as a way to ground a positive obligation for foreign corporations. There has also been a progressive development with the Hague Rules on Business and Human Rights, which are procedural rules modeled after the UNCITRAL rules on arbitration, which could give a framework for local communities to bring claims directly against investors within the context of investor-state dispute settlement. But you still need, of course, consent by the foreign corporation and a positive obligation. So consent could be obtained, for example, it has been done, I think, in some model treaties, African model treaties in the Gambia, as a condition precedent for investors to access the benefits of the bilateral investment treaty. They have to accept the obligation to respect human rights, and also they have to accept the Hague rules on business and human rights. And of course, positive obligations could be found under domestic law as a possible solution. And now I'm going to move on to human rights as a shield, so as a defense for states within the context of investment arbitration, which is a bit more developed. There are many entry points for human rights in an investment dispute at the stage of jurisdiction, at the stage of merits, when we talk about exceptions, and at the stage of damages. For the sake of time, I'm going to focus on, firstly, on the merits. So, to underscore the point that I made at the beginning of the presentation on the importance of domestic law. There was a case in Pakrim Cayman versus El Salvador. So Pakrim was an exploration, a mining corporation that was conducting exploration in El Salvador. So maybe you don't know much about mining, but mining is essentially divided into two phases. Exploration, which is a process of obtaining knowledge about what may be underground, and exploitation, which is when we move on to the construction and actual extraction of minerals. So construction of the mine and extraction of minerals. So in Pakrim was still at the stage of exploration, so there was no mine yet. And Pakrim wanted to move on to exploitation, but the state denied the exploitation license on the ground that Pakrim had not complied with human rights obligations under domestic law. So in this case, the arbitral tribunal took a very serious look on domestic norms and ascertained that indeed the corporation needed to obtain the consent of the owners of the land in order to move from exploration to exploitation. And it had not reached the consent of the owners of the land. So the arbitral tribunal dismissed the claim on expropriation and dismissed all of Pakrim's claims. So that is a way in which domestic human rights obligations can play a very important role. There is, for example, also a very good case on the use of systemic integration, which is South American silver versus Bolivia, in the claim of the investor on legitimate expectations. The investor claimed that the state's denial of cancellation of a concession entailed a breach of legitimate expectations, based on the legitimate expectation that the state's regulatory framework would maintain a certain stability that will enable the investor to move from exploration to exploitation. Now, what the arbitral tribunal said in that case is that the project took place in a very specific region where indigenous peoples inhabited, and therefore the corporation should have undertaken due diligence and realized that the state had a heightened duty to protect those communities in the ground. And therefore, there was no breach of legitimate expectations because the corporation should have foreseen the duties of the state. So these are two very good cases. There are others that are less progressive, and we can talk about them later during the Q&A. But before I conclude, I want also to point to exceptions and damages as points of entry of human rights. So exceptions are clauses within bilateral investment treaties that would enable, theoretically, a state to undertake human rights or environmental measures without breaching the substantive content of the bilateral investment treaty. So I have to emphasize that exceptions operate at the level of primary rules. If the exception applies, then there is no breach of the treaty and there is no compensation. There is nothing left to look at. But this is not, sadly, how some arbitral tribunals have interpreted exceptions. So for example, in the case of Eco-Oro versus Colombia, the arbitral tribunal decided that, well, even though the exception could be applicable to the case, the exception did not preclude compensation. So one is left wondering, then why do you have a general exception clause within a treaty? And finally, in damages, there are also ways in which human rights can play a role, and one of them is through the notion of contributory negligence. So for example, in the case of Copper versus Ecuador, the arbitral tribunal found out, and I quote, that the corporation had resorted to recruiting and using armed men, firing guns, and spraying mace at civilians, not as an accidental or isolated incident, but as part of a premeditated, disguised, and well-funded plan to take the law into its own hands. So with this finding, this fact finding made by the arbitral tribunal decided that the compensation that the state owed to the investor had to be reduced in 30%. So in the end, the state had to pay the corporation $19 million for a breach of the treaty. So to conclude, I think there have been some progressive developments that put some limits to the super rights that Federico just told us about, but there is still a lot more to do to bring investment treaties in line with human rights requirements. Thank you very much.
Thank you very much, Clara, for this very insightful presentation. I noticed you mentioned a lot of cases involving mining companies in Latin American countries, so they really seem to be a gold mine for human rights issues. And I want to explore one of the cases, I think the last case that you mentioned, that's the case of Copper Mesa against Ecuador, I think. So that is a case that was pending before the PCA, and there are currently more than 100 investor-state arbitrations before the PCA. Across the past decades, we've administered hundreds more, but there's only one that has given rise to a movie, and that is the case of Copper Mesa v. Ecuador. So could you tell us a little bit more about this case and its background?
Yes, so in Copper Mesa, the foreign investor was actually carrying on exploration activities within a zone inhabited by indigenous peoples. And there were violent confrontations that led ultimately to death of some civilians. And when the investment tribunal was adjudicating the dispute, in fact, it found out, it had evidence of many of these facts. And I have watched the movie. I think it's called On the Rich Earth, if I'm not mistaken. There are lots of movies regarding investment tribunals in the mining industry, and that is a very good one. And from my point of view, and I say this with a lot of respect, because there were very good professors working as arbitrators in that case, but that case should have been dismissed at the stage of jurisdiction. So the drafting of that treaty was wide enough. It contained a legality requirement that the corporation should comply with the domestic legal framework. And that phrasing of the treaty did not contain any limitation in time. So if there was evidence before the arbitral tribunal that this was not only respecting human rights, this was actually undertaking criminal activities, that case should have, in my opinion, been dismissed at the stage of jurisdiction and not proceed on the merits. But the arbitral tribunal took a more restrictive interpretation of the treaty and led the case to follow on the merits.
Thank you very much. And before I open the floor to the public, maybe one more question. And that is about, you said that arbitral tribunals are able to take into account and should actually take into account human rights considerations. Now, from a practical point of view, I can see an argument that an arbitrator would say, I'm actually reluctant to look at human rights because I'm no expert in human rights. I'm an expert on arbitration. I'm an expert on investment matters, not on human rights. So where do you see the role for amicus curiae submissions to maybe bring human rights expertise to the tribunal?
So there are 2 points in that question. I think, arbitral tribunals should have a background in public international law and then be able to take into account human rights, especially because even though investment arbitration is not the fora to actually defend human rights as you would in a human rights court, I think it is actually within their mandate to know what human rights limit the property right of the investor. And that is very important because otherwise you are overprotecting, and that's not the purpose of investment treaties, the way I see them. On the role of amicus curiae, I think it's very important, also as providing some sort of a remedy to local communities in access to justice is not perfect. More should be done. But there are also some limitations in accepting amicus curiae, some procedural constraints. So yeah, I think that's a part where we can have more progressive development. Thank you.
Okay, thank you very much. Do you have any questions from the audience for Clara? Oh, verständlich, yeah.
Well, thank you very much. This is a decades-long debate now. I was wondering, myself not being really a human rights expert, when we speak of human rights, we always assume this is a sort of consistent, inherent, clear regime, but on a level of applicable law, there's different layers of human rights, ranging from domestic to regional to international, probably universal. How is that to be sorted out dogmatically, and how do, as said, I'm not an expert, I did not follow that properly, but how do arbitral tribunals sort that problem out in practice? What's the sort of conceptual approach that you would, or dogmatics do suggest? What is the approach taken by arbitral practice, and other problems of, would assume, of inconsistent approaches too? Thank you very much.
Thank you so much for the question. So yes, indeed, it's very complex, also because these disputes are really complex in the regulatory framework, which is transnational. So you have the treaty, the bilateral investment treaty, but you also have environmental treaties, human rights treaties that are going to affect the dispute, and domestic norms. And there is a limit to what an arbitrator can grasp from the law. But I think it is useful to think in terms of, first, how is the property right configured? And that is where domestic law comes in. And there you have the pleadings of the parties. You have amicus curiae to feed into the reasoning of the tribunal. And you could also potentially have experts that come from the parties. And there you can reach somehow an understanding of how the domestic legal framework works. But there's still, of course, as you mentioned, a legitimacy issue, because some of these disputes have constitutional implications. So, for example, in Ecuador, the arbitral tribunal was citing decisions by the Colombian Constitutional Court. So you need to define a property right that is a core component of sovereignty, that is minerals. It's a core component of sovereignty. So there's a legitimacy issue that cannot be addressed within the current system. And then you move on to the level of international law, and there is where systemic integration, I think, is a very useful tool. And you can bring into the dispute, as has been done, for example, in Ecuador, in the decision on expropriation, the arbitral tribunal read into the bilateral investment treaty the importance of the precautionary principle. So there are ways to do it. It's not simple, and that there are still legitimacy issues in the disputes that arbitrators have to deal with.
Yes, by all means, Federico, please.
Question, Clara. When you say, particularly the positive examples where human rights are sort of come into an investment arbitration, and you can go back to the copper Mesa case, that was sort of used to reduce damages. But are there express reference to human rights, or it's simply that the tribunal looks at the killings perpetrated by the investor and then decides that, well, they misbehaved, but without qualifying any breach of human rights? They just take that as a fact and then take it into. So when we say that human rights come in, but how do they come in? Is it sort of in the minds of the arbitrators, or you read them as, well, this could be framed as a human right violation, but not actually, it's expressly made so?
It's a very good question, and it depends on the arbitral tribunal. So, for example, in the case of copper, it was a matter of fact, and that was addressed through damages. But in the case of South American silver versus Bolivia, or in the case of PACRIM, or in the case of Ecuador, only at the expropriation analysis, there was an express reference to human rights or environmental norms or the principle of systemic integration. So it depends on the arbitral tribunal. Some of them actually have express reference to the importance of human rights. And that is why I normally mention South American silver versus Bolivia, because it's a very powerful extract. Yeah.
Thank you. I think we had a question over there.
Yeah, thank you very much for the presentation. I just wonder if the cases that you mentioned made their way either in the ICSID annulment committees, just because they have the arbitration committee or arbitration tribunal, exercise this, human rights approach or the substantive law, either in annulment committee of ICSID or the, let's say, domestic courts. And maybe this is a hypothetical question, but do you think applying human rights norm or this kind of approach would be subjected to the before ICSID annulment committee as like manifest excess of power or manifest excess of jurisdiction? Thank you.
So if I understand your question correctly, you're saying that it may be an excess of jurisdiction to take into account human rights?
Yeah, because that is one of the reasons to annul an ICSID.
Okay, so it hasn't happened in these cases, and I don't think it could happen for two reasons. The first one is because the cases that actually take human rights in a positive light are very well constructed, in my opinion. It's not manifest access to jurisdiction to take into account the rules of the Vienna Convention of the Law of Treaties, and it is certainly not an access of jurisdiction to address the property right that you need to rule on. It's just domestic laws, and this has been argued by several scholars, Zachary Douglas amongst them. The property right is defined by domestic law. This is inescapable. Jan Paulson also argued that, and they are not, let's say, maybe saying something, that it's outside the boundaries of investment arbitration. And when you have human rights obligations embedded within the property right, you need to acknowledge that as an arbitral tribunal. So, not to my knowledge, they have not been subject to annulment, and I don't think they could be annulled in any case.
Thank you very much, Clara. And then we have a question from a gentleman in front.
No, thank you, Clara. It has really been extremely interesting. I think that you mentioned one case, if I understood correctly, in which the arbitration tribunal had argued that there is no legitimate expectation against the introduction of certain requirements which are justified for human rights protection. Now, was that based on an explicit reference to human rights in the applicable law, or was it a more general interpretation? Because that seems to me to have huge potential implications in correcting the super rights that Federico have been mentioning. It would be just a question of the host state adopting legislation which lays out sufficiently clearly the obligations of the investor. So on what basis, if I understood correctly, on what basis did the arbitration tribunal came to that conclusion?
In South American silver versus Bolivia, there was an express reference to the principle of systemic integration, and there was an express reference to the fact that the project took place in lands inhabited by indigenous peoples, and that the investor should have foreseen, and these are the words of the tribunal, that the state had a heightened duty of protection. So there was an express reference to international law. In the other case, the PACRIM Cayman, that was exclusively on domestic law grounds. So there was no mention of international human rights law. But still, domestic human rights are an implementation of the obligations of the state, of the international human rights and environmental obligations.
Thank you very much. And maybe the last question before we move on to our third speaker. Yes.
Thank you very much, Clara. So super interesting. I have a couple of questions, and I suppose that one that comes to mind is that this is enormously complex, right? Because we're talking about a tribunal that a type of adjudication that historically has been at pains in making sure that their jurisdiction was limited to a very narrow definition of dispute. And this is exactly what we see, for example, whenever there is an amicus curiae intervention, because the dispute is limited, perhaps artificially as well, as something that is really between the investor and the state. So, I mean, to me, this raises a couple of questions. The first is one of how do we fix these from the perspective of the process? Because, of course, there is a question, as you put it. It's not surprising, in my view, that Zachary Douglas would agree with Jan Paulson, but I'll get to that later. But one is a question of characterization of, like the property right and so on. But perhaps another question would be the question of the right itself as defined in the treaty. So I wonder, how much is this something that can be taken care of by treaty drafting? Now there is, of course, the new thing is carve-outs for certain types of measures. Is this a better approach to that, especially because it's becoming more and more difficult, especially when it comes to defining, for example, the state obligations as they relate to climate change, to know what they actually are. Now we have the Ethos Advisory Opinion, which went rather wild, so to speak, in creating, in defining the standard of due diligence applicable here. So I think this is something that, from a pragmatic standpoint, might require some further clarification and definition in the treaties themselves. So how would you go about that?
Thank you very much. It's a very good question that possibly UNCITRAL Working Group 3 could address. But I think there is much to be done in terms of drafting. So carve-outs are there for certain sectors of the economy, such as, for example, oil and gas, which are that's an option. We may want to keep other sectors of the economy within investment treaties. For those sectors of the economy, general exceptions could be drafted in much more clearer terms, and the role of general exceptions could be spelled out within the treaty. Legality requirements could be much more clearer in treaties, and the obligation to comply with at least domestic law could be spelled out in the treaty. And those are very minimum amendments that could be done to address the issue. Thank you.
Thank you, Clara. And with that and a look at the clock, I think we should move on to our third speaker, and that is Professor Mavluda Sattorova. Mavluda is a professor of international economic law at the University of Liverpool, and in her presentation today, she will focus on what is referred to as the good governance effects of investment treaties, and she will help us find an answer to the question whether investment law improves governance. Mavluda, the floor is yours.
Thank you, Levent, and thank you to Federico and Clara, because what they just said provides a very useful background to my own contribution. So as Federico's presentation highlighted, international investment law is the law of super protections for investors. And as Clara highlighted, those super protections have a wider ramification of a societal nature for the local communities and beyond. So this interplay between international investment law and good governance is the area where some of those ramifications of super protections for investors is being discussed. For me personally, this interplay became visible when I was in my post-PhD phase of luxuriating in freedom of reading what I want and reading for pleasure. And what I noticed that there was a proliferation of certain narratives about international investment law, the narratives that ascribed to it good governance effects. And that was during a time when international investment law was rapidly expanding, and indeed, the fact that it was affording foreign investors with super protections prompted the need for new, additional and stronger justifications and rationales to explain the raison d'etre and the existence of the regime. So the good governance narratives of international investment law usually assume that the pain of damages awarded to the investor as a result of finding of a breach would result in that host state responding to that pain by reforming its domestic processes, by reforming domestic governance. And it is very often linked to the fair and equitable treatment, in particular to the FET standard, in the sense that the FET standard lays down some form of a benchmark to which host states should aspire, not only in their dealings with foreign investors, but in general. So, and the resulting effect is that international investment law, by creating those super protections, is also very good for the host state and for host communities in general, because it would then precipitate various domestic reforms, improving domestic bureaucracy, the functioning of the judiciary, institutions, and so on. My project was to test those assumptions and those good governance narratives with the aid of empirical data, that is, by looking at what happens in the post-award phase. So once the award is issued against the host government, awarding damages to the investor, what happens then? Does the state indeed, repent, reconsider its ways and think, well, now we need to improve and stop misbehaving, so to speak? And what I found as a consequence by conducting those empirical case studies, so we focused on a number of developing countries, because a project of this kind, obviously, you need a lot of longitudinal and latitudinal empirical work to paint a broader picture. Ours was more of a select snapshots of empirical data just to test some of those good governance effects, narratives and assumptions underpinning them. And we focus primarily on developing countries because the good governance narratives tend to be applied in particular in relation to developing countries, because it is often assumed that developed countries don't really need to change much in their governance, it's already good enough. So what I found quite fascinating and in some ways surprising, that I set out doing those empirical studies with certain assumptions. I said, well, I will interview my government officials and I know what they're going to say in response. And yes, some of the responses were not surprising, but some of them were. So what was revealed as a result of all of that empirical analysis is a rather complex but very rich picture. First of all, it transpired that there were no good governance effects for a very simple reason, that in many developing countries, the levels of this profound and detailed awareness of what international investment law does and how it's going to affect the host state, if there were to be disputes, is very low. And that is because even if the learning happens as a result of the initial encounter of the state with investment arbitration, that learning is then lost because of the high turnover in government institutions, because of the absence of the mechanisms through which that learning could be translated into the reform. But also, very importantly, and that's something we were talking about yesterday with Federico, is that international investment treaties themselves do not have those mechanisms within their design. So neither the treaties nor the ISDS mechanism have anything in their design that would enable that kind of learning and translation of learning into the broader improvement of the lives of those who are affected by international investment law and in general bureaucracies and domestic governance frameworks. What then myself and a number of other scholars who were increasingly turning to critiquing and testing good governance narratives argued that what would be needed for the good governance effects to take hold is that treaties themselves and relevant compliance mechanisms should be there in place. And what the empirical data found that there are no such compliance mechanisms on the ground, or if there are, then they are actually of a very different nature. That makes me, that kind of, when I was thinking about this talk today, to link it to what we've heard yesterday, Professor Sarmiento, for example, talked about the values and human rights, how the European Union exports broadly through its deep integration and free trade agreements, but it does so in a fairly thought-through way. They are indeed embedded in those agreements, and there is this broader agenda of, whether you call it exporting, enforcing, or otherwise, but there is an intention to transpose those norms and values into the workings of the states with which the European Union contracts when it concludes free trade agreements and other deep integration instruments. In international investment law, there are no such intentions. International investment law ultimately is about protecting foreign investors. And whether we like it or not, it actually does it very well. Yes, indeed, it does protect foreign investors well. But to ascribe to it this broader good governance effects is somewhat misplaced. So one of the unexpected findings of my empirical research, but also the empirical research that followed in the recent years, so Julia Calvert has done some work, Jonathan Bonniccia, Zoe Williams, and what the bulk of those emerging empirical studies showed that there are certain mechanisms that exist in parallel to international investment agreements and ISDS, which do, in a sense, work with a view of transforming what the states do on the ground, or transforming how they govern, how they operate their wider governance frameworks, including investment governance. But those mechanisms are not the product or the creation of investment treaties or ISDS. Just to explain what I mean, both my own empirical studies and others showed that there are certain mechanisms that are being created, such as dispute prevention agencies or investment promotion agencies or investment ombudsman agencies. But those institutions are not created because of international investment law. They are created in parallel to international investment law by international organizations and other reform entrepreneurs. And they have a broader agenda of indeed transforming the ways in which host states interact with foreign investors on the ground. But again, what the empirical data shows that even those institutions that are being created in parallel to international investment law and arbitration actually lead to overprotection of foreign investment. So they do not necessarily have those positive spillover effects through which the broader, the fabric of the society and the broader range of stakeholders on the ground would benefit from that. So again, we see those super protections, but those super protections now are being institutionalized through the workings of international organizations such as the World Bank, for example, and more recently, this whole agenda re-emerged again in the work of the UNCITRAL Working Group 3, in particular its dispute prevention agenda, because we see that debate about, well, do we need those new centralized agencies that would be empowered to resolve investor-state grievances before they escalate into investment arbitration cases. But the idea of that empowerment, again, centered on the same values as we see in international investment law. That is, you know, you need to get this sorted, at whatever cost, but you just need to make sure that the investor is satisfied. So it's that idea of achieving a certain outcome that would be acceptable to the investor. So for now, and I know that my presentation is final, and there's a very much needed break for coffee and discussion. For now, I'd like to conclude with the final overarching observation. So the work continues, and even though there are more and more empirical studies coming in, and the studies of the critical nature, asking actually a wider set of questions, and for example, do we even need to improve good governance in developing countries through international investment law? And to what extent there are elements of hypocrisy in undertaking that work, and so on. So this could be linked to broader critical legal studies or the law in development studies and so on. But for us, the scholars of international investment law, what seems to be clear to me is that when we look at the governance effects of international investment law, investment treaties and ISDS, we need to embrace and appreciate the discipline understood more broadly. We need to look beyond investment treaties and ISDS and understand that very often those two operate in conjunction with other parallel mechanisms that have sort of a transnational nature, that have their own unique aims and objectives. So to test the effects of all of those, we need to embrace, indeed, a broader understanding of what constitutes international investment law. Thank you.
Thank you very much. Thank you very much, Mavluda. And that was a very interesting presentation, and I liked in particular the point, well, the results of your research, which showed that there was maybe a lack of capacity or a lack of knowledge in developing countries' governments about the effects of international investment law. And as you know, there are a couple of initiatives in the field that have identified that issue, and they're trying to address it. The PCA, for example, we do some capacity building for our government officials of our member states, but it's also the International Development Law Organization, which has set up this investment support program for least developed countries, and has also been taken up by UNCITRAL Working Group 3, which in April of this year has completed its work on a draft statute for an advisory center on international investment that also seeks to assist, especially developing countries, with these matters. How do you see these initiatives, and do you think they can have a beneficial effect on capacity in developing countries and can actually improve that power imbalance between developing countries and developed countries?
Thank you. This is such a good question. I was asked this question a few years ago, and I remember I said, yes, capacity here is extremely important. Capacity needs to be built. To be honest with you, that capacity needs to be built across the board. It's not just developing countries anywhere. Understanding what international law does, what effects it has, how these treaties operate is incredibly important to any government, any country. But when I raised that in relation to developing states, someone from an NGO sitting in that room, they said, please, by saying so, you are denying agency to developing countries. And I thought, well, I need to go back and rethink what I'm doing. But one thing that emerged from those empirical interactions, the empirical studies, and in particular interviews, was actually very humbling. So we scholars set out with so many different assumptions about this is good, this is bad, this should work or not. But what emerges from the ground is much more varied and very, very complex. So some of my respondents, for instance, said that capacity building, yes, but to what extent can we trust certain capacity building initiatives if the people who come to tell us about international investment law, I mean, no offense is intended, but they say they are effectively counsel at leading law firms or arbitrators, or indeed representatives of organizations such as the World Bank. So it's like, to what extent there is an element of skepticism, there is an element of mistrust towards whether those views that are, the capacity building agents, are they actually acting in the interest of those whose capacity they're trying to build. So I still believe that capacity building is important, but I think those concerns need to be taken into account in designing those capacity building initiatives. So there is a bit of a bottom-up interaction, as well as taking into account the concerns and the need to address the mistrust that certain developing countries and communities within countries may have in relation to various institutions.
Thank you. That's very thought-provoking, actually. Yes, thank you. Do you have any audience questions for Mavluda? Yes, please. The microphone is on its way.
Please speak closely to the mic. Okay. Thank you very much. That was very interesting. All three presentations were very interesting. But on the empirical aspect of which you just explained, I would like to introduce maybe two derogations to your findings, but they're purely empirical, so there might be new lines of research on the empirical side. If we look at Spain, my home country, Spain has become kind of the pariah state of investment arbitration lately. And this is mostly as a result of a legislative reform that had a significant impact in investors, international investors who had invested in renewable energies in Spain in the late 2000 decade. This has triggered an unprecedented wave of investment arbitration claims against Spain. This is well known in the arbitration community. My conversations with the officials in the Spanish ministries which have been involved is that the experience, which has been quite traumatic because of a lack of any kind of precedent in dealing with these kinds of claims, the lack of understanding of how they function, the lack of experience among the state lawyers, the trauma that this has caused internally has probably changed things quite considerably. A reform like the one introduced in 2011 that triggered these claims, which probably had no consideration whatsoever to these risks, would certainly not be handled in the same way at present. Not at all. And here my doubt is, and that's why it might be an empirically interesting point to research, to what extent does this have to do with the fact that this is mass litigation? Because this is mass investment litigation. If this would have been one single case brought against Spain, I think nothing would have changed internally in Spain. And then your empirical findings would have been confirmed. But because this is mass litigation, I don't know exactly what the numbers are, but it is mass litigation, it has changed things quite considerably. You know, the entire infrastructure of reaction of the Spanish government has had to change because of the scope of the risk attached. So to what extent does the mass feature might actually condition the governance consequences coming up? And this is not just an isolated feature of the Spanish case. Mass litigation is growing domestically. It's something that was very exceptional before, but now we're seeing an emergence of mass litigation pretty much in all states, and now it's emerging in international law as well, and investment claims in the case of Spain show that mass litigation can also happen there.
That is such a good question. Thank you. I was thinking, indeed, so within the short time given for my presentation, it was difficult to kind of also explain that the findings of that first empirical project were actually showing that across different countries, so we looked at a number of Central Asian states, Turkey, Jordan, Georgia, Ukraine, Nigeria. What we found is that each state actually responded in its own way. It's just the sort of the bigger good governance picture, and some of the key good governance arguments do not quite hold in the face of that data. But what you are saying is indeed a very important question for further empirical studies, and I would say there are two reasons there to indeed look into it more closely. One, how developed countries respond to that. I love that word trauma. If you let me, if you allow, I would steal it. Absolutely, this is spot on. How the traumatic encounter with investment arbitration of the kind experienced by Spain, partly Italy and others, to what extent within that short period of time, enormous exposure, how is this going to affect Spain's internal workings, but also its broader relationship with international investment law? That is yet to be tested, so there are two different parameters there. Developed country, but also the extent of its exposure. And so I agree with you. There's more correctives to be made to these studies and the more findings to unveil.
Well, withdrawal from the ECT, that's the first response. But can I have a question?
By all means.
Oh, yeah. I'm interested in what you said about this new strategies, right? Sort of governance strategy that are not connected to traditional investment protection, but sort of, you know, preventing disputes, sort of facilitating investor talking to local authorities. You haven't mentioned it, but this all now comes down within the word of facilitation. Partly, yeah. Well, there's quite a lot, you'll see, which is how the WTO has taken over at the multilateral level. So I'm interested in what you said, that what's the interaction between this complementary or alternative ways? I mean, most of the rationale is to attract investors, and in fact to retain investments, right? Once they are there, if they struggle to get a license because it takes, you know, 6 years to get it renewed, that doesn't help retaining investors. So they're trying to sort of deal with all this red tape and possible complaints. Now, what is the interaction between this novel approach, which is supposed to be different from the old, right? Granting rights and sort of protection, ISDS. So that's not it. But what's the connection between the new approach and the old, the existing? Because you seem to say that the existing investment protection, the super rights, the way is now influencing also this alternative, which is supposed to be different, less controversial, more dealing with red tape, is also influencing this alternative way?
Yeah. It is and it isn't. So in some ways, there's a very interesting report that was written by Jonathan Bonniccia and Zoe Williams for IASD, where they looked at the partly intersection between investment facilitation agencies that are emerging, but also investment promotion agencies, investment ombudsman, investment dispute prevention agencies, and that sort of, their wider interactions, but also their divergent and convergent features. To me, they indeed, where they overlap with international investment law is the idea that it's foreign investors' interests that need to be prioritized, and that it's foreign investor grievances with host state that need to be resolved, preempted, apprehended, and so on. So again, we see that kind of prioritization of certain policy objectives over others. So that's where they overlap. But I agree with you that also they have their own effect, and that's why my final conclusion was that we need to look at the broader field of international investment law, including all of those transnational initiatives, including the WTO's JSI on investment facilitation, in a sense that they actually have different functions and they broaden the substantive scope of what we may see as the broader international investment law, because they indeed now have the function of promotion, retention, and so on. And again, empirical data there is also quite interesting, where you look at, so emerging empirical data suggests that some of these investment retention mechanisms do not work. If the investors want to leave, they will leave. And again, the emphasis is to what extent that over-prioritization of investment interests is a thing. So investment facilitation agreement that the WTO is trying to take off the ground, which is still kind of pending because of the implementation thing, is introduces this thing of indeed improving transparency, resolving all of those issues on the national ground in reasonable, objective, and etc. manner. But if you look at where it applies, they say, well, it applies to dealings between a range of domestic agencies with foreign investors. So the wider governance effects are still yet to be tested.
Thank you very much. I see we're running out of time, but maybe we have time for at least one more question from the audience. Professor Wittig.
Thank you very much. I mean, the more I think about it and the more I hear about it, I don't know who came up with the idea that investment protection law would really be an effective tool to improve good governance or even to establish it. I mean, this is so systematic or systemically flawed on various levels. I mean, if what Daniel said with regard to the trauma caused to Spain and to Italy, I mean, think of the trauma all that investment arbitration has caused collectively mass claims to the global south, right? Then the problem, it's from outside. I mean, you have the population, you have the civil society, you have indigenous populations, all rallying behind their governments, right? It's imposed, it's not often voluntary. Then the problem of knowledge, awareness, not talking about the people, but even government officials not even knowing about the system, and caught by surprise. And then you have the problem of sort of partners in crime, in a sense of the government dealing with the foreign investors, and then all of a sudden you have a triangular relationship, foreign investor, government, population, and so on. And I think of just the parallel, the conditionality issue and the ineffectiveness as we know it from our own experience in the European Union, human rights. It will never work. I mean, investment protection has been designed, as I understand it, and again, I'm not an expert in human rights law nor investment law, as a tool to promote investment, retains investments, foster economic development, and probably with that, social development and all of that, but not good governance of all reasons. Thank you very much.
Thank you. And yes, indeed, the flawed nature of those narratives was something that made me think that, well, this is something to be studied. And there's a very respected line of authors who have proposed those narratives, but to them I'm grateful because it gave me a few years of working on this project. I say that, for example, I almost single-handedly owe this to Stefan Schill because he said those things and I was like, yeah, I've got a book out of it now just by contending that he wasn't right.
I'm sure Stefan will be thrilled to hear that. Well, thank you very much. I see that we've ran out of time, so it's up to me now to thank the audience for your kind attention today and to thank again our three speakers for their very excellent presentations. Let's continue our discussions over coffee, and thanks again.